So let's start with why California law matters so much. California law is different. Number one, because there are so many detailed state law requirements in California. It just has more laws on background checks than any other state in the country. It has a law dealing with background screening reports generally. It has various laws dealing with credit check reports. It has laws dealing with what types of criminal history information employers can use, what types of credit history information employers can use, how employers can use sex offender registry information and how it can't. California just has more laws. California also allows individuals to recover damages in a way that most other states don't. So we talked just a moment ago about the fact that California has a law that covers background screening reports generally and the technical requirements for employers generally. Well, that law says that even for an entirely technical mistake that does not produce any actual damages, an individual can recover a minimum of $10,000 per violation. Let me say that again, $10,000 per violation, even in the absence of harm. That's different. And that means that California law deserves more attention than most other state laws. Third, California is really a hotbed for litigation. You know, we probably see more background screening cases in California than just about anywhere else. And that's true both at the federal court level and the state level. And finally, California is sort of known for having a left-leaning set of judges. Sometimes I think the media and the general public exaggerate a little bit on that, but I think to some degree it's true that California judges tend to skew a little bit more left than we would see in certain other places. So all of this together creates a set of ingredients that make California more important on the background screening front than just about any other state. So how do you know whether California law applies or not? And the first thing to know in terms of how do you know whether California law applies is that there really isn't great information out there on that. The statutes, by and large, as well as the cases, tend to give unclear answers on when California law applies. And so we're really left to use our best judgment in most circumstances as to when California law applies. And most of us think it's going to apply in one of the following two circumstances. If the candidate or employee is residing in California at the time of the background check or the background screening decision, or two, if the candidate or employee is going to be working in California, but may be residing out of state at the time of the application. We think those are the most likely situations in which California law would apply. Because generally, background screening laws are considered consumer protection laws. And we think an individual will have the best chance to say, I should be covered by a state consumer protection law if they have a substantive connection to that state. And certainly if they reside in that state or if they are applying to work in that state, there likely is that substantive connection. If it's a close call, if you're uncertain, does California law apply, does it not apply, it's generally best to assume that it does, because California requires more things of employers than just about any other state. So if you're complying with California law, you're probably going, if anything, above and beyond the call of duty. And when it comes to California law, we'd rather err on the side of caution and satisfy it than err on the other side and take our chances. California is not the state that we like to take chances with. So which background screening areas require special treatment when it comes to California law? Well, the first area is the written consent for the background check. So all of you that are listening to this call today, I'm sure are aware that there is a federal law requirement under the Fair Credit Reporting Act for how employers go about securing written consent for a background check. And the federal law basically says that that an individual that might be subject to a check has to, number one, receive a disclosure that says a consumer report may be obtained on them for employment purposes. And then number two, that they have to provide written consent to that receipt of the consumer report by the employer, right? But as you've probably heard, there have been a mountain of lawsuits in recent years about those federal requirements. They sound very simple, but in reality, there have been a huge number of lawsuits saying that the employer is fouling it up for one reason or another. Now, I know we're talking about California law today, but the reason I bring up this federal law requirement is because the Ninth Circuit, which is the Federal Court of Appeals that covers California, has now interpreted the Fair Credit Reporting Act's consent requirements in very, very narrow ways. There was a case that came out about 2 months ago called Gilberg. And in Gilberg, the Ninth Circuit reached a decision that is a surprise to many of us that pay attention to this area. And what the Ninth Circuit said is that that federal notice, that disclosure saying we, the employer, are going to obtain a consumer report on you for employment purposes, is invalid if it includes certain additional stuff, right? Now, the Fair Credit Reporting Act says that that disclosure needs to stand alone. That's where this all comes from. But many people believe for a long time that it would be okay to include certain supplemental pieces that are related to the issue. So for example, include state law notices that may be required, or include references to a governmental notice called a summary of your rights under the Fair Credit Reporting Act. That if there were related things, those could go in the disclosure. But the Ninth Circuit just a couple months ago came out and said, we don't think that's the case. The disclosure truly does need to stand alone, and there are no free passes, even for items that seem related to the Fair Credit Reporting Act disclosure. So now the best practice wisdom, certainly for employers that are operating in California or receiving employees or applicants in California, is to make sure that they take a second look at the disclosure and authorization materials that they are using. Number one, to make sure that that disclosure does not include a variety of state law notices, as used to be common about 5 years ago or so. And number two, that it doesn't include any other types of potentially extraneous information, such as a summary of your rights under the Fair Credit Reporting Act, which is a governmental notice. The key takeaway based on this Ninth Circuit decision is that background screening consent materials, even at the federal level, are going to remain under significant scrutiny, and that certainly for employers that are operating out west, they're going to want to be extra careful, because courts out on the West Coast right now are going to be interpreting these federal Fair Credit Reporting Act consent requirements even more rigidly than they did before. And I can tell you, we work with employers every day on their background screening consent materials, as well as background screening companies. And we can tell you as a general rule, less is more. Where employers are getting into trouble today is when they're throwing in too much stuff into that Fair Credit Reporting Act disclosure. We're not seeing many cases on the flip side saying that there is too little in there. It's best to involve legal counsel on the background screening consent paperwork at this point, because the risks are too high, particularly if you are operating out on the West Coast. Let's continue to talk about written consent for a minute, because California also has state law requirements that go above and beyond what federal law requires. So California state law says it's not enough to tell a job applicant or employee that a consumer report may be obtained upon them for employment purposes and to obtain written consent as federal law requires. If California law comes into play, an employer needs to have an additional piece of paper that says additional things. And what you see on your screen right now are examples of the types of information that is required to be conveyed under California law that is not required to be conveyed under the Fair Credit Reporting Act. For example, there's references to investigative consumer reports instead of just consumer reports. The terminology is a little bit different. The disclosure has to make clear that the background screening report may include information on the individual's character, general reputation, personal characteristics, or mode of living. The name, address, and telephone number of the background screening company needs to be identified in the California disclosure, as well as the background screening company's privacy policy. Where can that be found on the website? There are certain additional rights under California Civil Code 1786-22 that must be disclosed to the consumer, and there also has to be a checkbox for the job applicant or employee to mark to indicate that they would like a free copy of the background screening report that's being ordered by the employer. All of this stuff is separate and apart from the standalone disclosure under the Fair Credit Reporting Act and is usually handled on its own piece of paper. Keep in mind that that same Ninth Circuit case that I mentioned to you just a moment ago dealt not only with the Fair Credit Reporting Act's consent requirements, but also California's consent requirements. And it found that the employer was making a mistake as to California requirements too. What we see happening in the upcoming future is a continued surge in cases accusing employers of using invalid consent paperwork. And the idea is, if you've used the wrong background screen consent paperwork as to one person, you've probably used the same wrong background screening consent paperwork as to every person that has come through your system. And that is the key ingredient for a class action lawsuit, which is why plaintiffs' attorneys find this area so attractive. Last issue with regard to consent has to do with
Well, Scott is pulling up the presentation again. Just a reminder that if you have any questions for him, please put them into the chat, and then we'll be sure to ask them afterwards.
Sorry, everybody, one moment.
It was funny before the webinar today. Scott and I were joking that, if there's a technology snafu, this happens to him all the time. So.
Only me, only me.
We may have cursed the webinar today.
Sorry, everybody, we'll be up here in just a moment.
There we go.
All right. So what I was about to say is that California also has specific written consent requirements as it relates to doing credit checks on job applicants or employees. In the wake of the recession of 2008, 2009, 2010, California said, we don't really want employers to be running as many credit checks on employees and job applicants because we think that individuals are going to have an increasingly difficult time with their credit situation. And the last thing we want is for California individuals to have a hard time getting a job in the wake of the big recession. So California passed a new law that says employers are only allowed to run credit checks in very specific situations. California law identifies 10 permissible bases under California state law by which they can run credit checks legally. The most common ones relied upon by employers are what you see on your screen. So employers will say, we are running a credit check because the individual occupies a managerial position, or we are running a credit check because the individual will be a named signatory on an employer bank account or on a company credit card. All right, those are the two that come up most often. The key thing to keep in mind, though, is it's not only necessary to have a permissible basis under California law to run a credit check on a job applicant or an employee, but also to disclose that basis at the time that you are seeking consent from the individual to run a credit check on them. So California actually says you have to identify the specific permissible basis under California law by which you, the employer, can run a credit check. Where we are right now with respect to California credit check law is that really it's a best practice for employers only to be running credit checks on a very limited number of positions. In general, employers are now transitioning to only running checks really on CFO type positions or on accounts payable type positions, or occasionally when individuals are going to have a company credit card or something like that, or certain managers that have particular discretion as to the company bank account. But in general, there has been a decrease in focus on credit checks, and the smart advice today is to be more careful in terms of the situations in which you might run a credit check. What we're going to move on to now is away from the written consent requirements and to your substantive review of background screening information. So imagine now that you have gotten written consent, you've gone through Orange Tree to run the background check, and now you've received a report that has certain criminal history information or certain sex offender registry information. What can you do with it? What can't you do with it? Well, California, unlike most states, has very specific limitations on what an employer can use and cannot use, particularly on the criminal front. So, for example, an employer subject to California law cannot use pretrial diversion information. So many times, individuals that have their first run-in with the law, right, will be presented an opportunity to essentially agree to plead guilty or agree to no contest, and then sign up for essentially a probationary term. And if they satisfy the probationary term, meet all the requirements, then the case essentially goes away. It's dismissed or it's expunged or whatever. Well, California law says if someone enters that type of program, it can't be used against them in the employment decision. Likewise, California is jumping on the marijuana bandwagon and making it more difficult to use marijuana usage against applicants and employees. So a new law in California essentially says that if someone was convicted of misdemeanor marijuana possession more than 2 years ago, that conviction cannot be used against the job applicant or employee. Similarly, California law disallows employers from using juvenile offenses or non-convictions in their employment decision. So imagine, for example, an individual was charged with murder, but ultimately that case against them was dropped, or ultimately that case went all the way through the criminal justice system and they were acquitted of that charge. Under California law, an employer cannot use that sort of charge against them. Another thing that's really different about California law is it places strict limitations on the ability of employers to use sex offender registry information. And I would say that California's law in this regard is more restrictive than any other state in the country. So California says an employer can only use sex offender registry information to quote unquote protect a person at risk. So the question I always get from employers is, well, I'm kind of concerned about bringing in someone that's on the sex offender registry to work in our office because I think that everyone at our office is at risk if they're surrounded by someone on the sex offender registry. And while I understand that rationale and point of view, that's not exactly what California has in mind. It appears to us that what California is focused on is protection of particularly vulnerable people. So children, the elderly, individuals that may have physical or mental health issues, those are likely the people at risk that they have in mind, those types of individuals. Which means that in many situations, your run-of-the-mill situations where a job applicant is not going to be working at a nursing home, is not going to be working at a daycare or school, is not going to be working with individuals with special needs, that in many of those situations, an employer is not going to be able to factor in the sex offender registry information into the decision. And that's a big issue for many employers. Last thing is that there are certain municipal laws in California that further restrict employers. So for example, San Francisco says that an employer can't consider a conviction more than 7 years old. So imagine that murder situation that I mentioned a few minutes ago. Imagine someone actually was convicted of murder 25 years ago, or even 15 years ago, or 10. Under San Francisco law, that's off limits. The employer is not in a position to consider that. So a big take-home message here is that California places very specific black and white limitations on employers in certain areas where it comes to the background screening report. And to the extent you don't have a good command of those areas, it's a good idea to reach out to legal counsel or an HR consultant on that issue to make sure that you're familiar with it. So let's assume for the sake of argument, though, that you receive a background screening report and it has certain criminal convictions identified in the report. And those criminal convictions are not off limits in the ways that we just described. Let's assume that theoretically they're usable to you. California law also in the last few years has introduced a new process that employers have to follow if they are thinking about taking action based on that criminal conviction. So the first step under California law is that an employer has to make an assessment of whether a particular conviction is in fact job related. So they have to look at the nature of the crime. How serious was it? Was it a big deal or a small deal? They have to look at the nature of the job. Is the job kind of sort of connected to that conviction? Is there a reason to think the conviction bears upon someone's qualifications to do the job or not? And third, the employer has to think about how much time has passed since the offense and essentially give greater weight to more recent convictions. So if someone was convicted of assault 25 years ago, that assault would carry less weight than a situation in which someone was convicted of assault 1 year ago. Make sense? So California law's requirement really builds upon what the Equal Employment Opportunity Commission recommended in its guidance in 2012. So it took the EEOC's guidance from 6 or 7 years ago and said, we're going to make that law. So here's an example of how it can be challenging to evaluate job relatedness. So imagine a felony driving under the influence, right? Many employers would tell me, wait a second, a felony DUI sounds quite serious. I don't want to hire someone that has a felony DUI driving under the influence because it suggests to me that they're a reckless person, right? Well, what California law is likely thinking on this topic is, well, is the person going to drive or not, right? If they have a felony DUI from 2 years ago and they're going to drive a significant way as part of the job, then sure, there's probably a job relationship there. But what if the person is just going to sit in an office like I'm sitting in right now, and they're going to be looking at a computer all day and they're really not going to be driving as part of the job? Is that really job related or not? California law is certainly skewing towards the idea that that's probably not job related, and the employer should probably not be considering that as part of their decision, or at least not taking action in that type of situation. So California law says the first thing is that an employer has to evaluate job relatedness. But don't stop there. California says, okay, let's assume for the sake of our argument that the job is related. Then the employer also ought to look at whether the candidate has supplied information or evidence that suggests that they are less of a risk or less of a threat than their background screening report might suggest on its face. So for example, have they worked a similar job as what they might work for you in the last recent years, such that you know that they've already done this job and haven't had a similar problem like they did with their criminal conviction? Have they gotten new education since the crime? Have they gotten rehab since the crime? Have they been bonded since the time of the crime? There's a variety of factors that the EEOC has recommended that employers take into account. And we think California law is likely going to be focused on those very same factors. And the key is to essentially evaluate, okay, we might have a job-related crime, but is there reason to think, based on the individual's experience since the time of the crime, that they really don't present as much risk as might have first appeared from the face of the report? A few thoughts on this to conclude this slide. One is that it's getting harder in California law to say, yep, we want to exclude somebody based on their criminal history. And so it's more important or more worthwhile to think about consulting with legal counsel today in that context than it was even 3 or 4 years ago. And the second thing is, on the second step where you're evaluating whether the information, whether the person has been rehabilitated or had mitigating circumstances or grown or developed since the time of the crime, many employers find it useful to develop a written questionnaire and to send the written questionnaire to the candidate and essentially ask them to provide additional information about 7 or 8 or 9 different things, different categories that reflect on what has transpired in their life since the time of the crime. Employers find that useful, number one, because it's a standard form that can be sent out to everyone. We help employers all the time with those. And the other reason it's useful is because it provides written evidence that you are in fact thinking about that sort of information. And that's both in keeping with what the EEOC recommends at the federal level, and it's also in keeping with the direction of California law. So let's assume you evaluate that criminal history information and you decide it's job related and there's nothing about the individual's growth and maturation and development since the time of the crime that convinces you they're less of a threat. And so you've decided that you don't want to hire this person, right? Many of us find ourselves in that situation. Well, you know under the federal level that there is an adverse action requirement, which is essentially a letter writing campaign. That under the federal law, the employer has to send out a letter to the applicant saying, essentially, we're thinking about taking adverse action against you. Here's a copy of your background screening report. Here's a summary of your rights under federal law. Please tell us if anything in the report is inaccurate so we can take that into account. And then there's a waiting period to see if there is, in fact, any inaccuracy or dispute about the accuracy. And if not, the employer closes the loop by sending out an adverse action letter that satisfies very specific requirements under federal law. That's the federal law requirement. But California builds on that and requires additional things. And what we often find is that employers are doing a decent job of satisfying federal law, not always, but most of the time doing a decent job of satisfying federal law. But the overwhelming majority are not yet tackling California's new requirements. So California has new requirements both for the pre-adverse action letter and for the adverse action letter or post-adverse action letter that closes the loop. And what you see on your screen are examples of requirements in California that don't exist at the federal level. So one example is that an employer has to identify the specific part of the background screening report that's causing the potential adverse action. So imagine a situation in which the background screening report indicates that someone has been convicted of 5 different crimes, but 3 of them don't matter to you. They're the DUI or the marijuana convictions that you might not even be able to use, right? But 2 of them are quite serious. One's for, felony battery from 2 years ago, and one is for felony attempted murder from 2 years ago. And you decide, yep, that is why we're concerned about hiring this person and going through the pre-adverse action process. Well, California law says in the paperwork that you provide to the applicant at the pre-adverse action stage, you need to identify that specific part of the report that's prompting you to send the pre-adverse action letter. Likewise, you have to inform the individual of their ability to give you evidence regarding potential rehab or circumstances that might suggest that the crime is less of a threat to you than you first thought. California law also says, in a way that's less clear under federal law, that you have to provide the candidate or the employee at least 5 business days to respond. So let's say you get through the pre-adverse action letter and then you go through the waiting period. There's no dispute about the accuracy of the report, and so you proceed with the adverse action letter that basically announces we are not going to hire you, and you satisfy all the federal requirements. Well, California also has additional requirements again. You have to reiterate what is the part of the report that's causing the adverse action letter, and it may be different than at the pre. So in the example I gave where there were 2 convictions that caused you to send the pre, maybe the evidence that you heard leads you to believe that one isn't all that significant, and you're not going to factor in that one conviction anymore, but one conviction does remain very important. Then that's the one that you're going to want to identify in the adverse action letter. Likewise, there are requirements now under California law that an employer indicate to the applicant or to the employee that they have a right to file a complaint with the state agency that processes discrimination complaints under California law. So that's different, and it's different in a way that most employers are not yet accounting for. I would also add that municipalities are also jumping on the bandwagon. So Los Angeles, for example, now requires employers to complete a very specific form that essentially asks employers to provide their balancing type analysis on criminal convictions to the job applicant or to the employee. That sort of form is available. If you just Google Los Angeles Fair Chance Act notice, you'll see the notice that is required to be filled out by the employer. and provided at the adverse action stage. And Los Angeles actually requires the notice to be provided in part at the pre-adverse action stage and in part at the post-adverse action stage. The big thing to remember with regard to adverse action letters in California is that it's a fast evolving area. And so to the extent you haven't taken a look at it in recent years, you're using the same letters that you used 5 or 10 years ago, it's worthy of consulting with counsel or doing some of your own digging on the topic. A few other unique items before we move on to your questions. California law now says that an employer cannot run a criminal history background check until presenting a conditional offer to the candidate. So it used to be that some employers would run checks earlier, say post-interview or even pre-interview. They'd run it on their last group of candidates, 4 or 5 people that the process has funneled down to. Now under California law, a criminal history background check cannot be conducted until the conditional offer stage. Second, we still have some employers that want to charge job applicants for criminal background checks. And in most states around the country, an employer is permitted to do that, or is at least not explicitly prohibited from doing so, but that's not true under California law. Criminal history check costs cannot be passed along to the job applicant. And the final thing I wanted to mention before we move on to your questions is that California has a unique requirement that an employer provide a free copy of a requested report if that sort of request is made to the employer. So you have a job applicant that says, gee, employer, I want to see what you got on me. You, the employer, are required to provide a copy of that report within 3 days. And we do see cases crop up where an employer does not satisfy that requirement, or at least does not satisfy that requirement in a timely way. Covered a lot of information in about 30 or so minutes, and we've even managed to do it despite the technology snafu. But I'd love to hear what questions you might have about California law.
Great, thank you, Scott. I do see a couple of questions in the chat. Just a reminder that if you have something that you'd like Scott to answer on the webinar, please type that into the chat and we will ask them today. So let's see, the first one, this might be specifically related, like an industry question or a job function question, but what if you provide services in the homes of those protected class?
Mm-hmm. Yeah, good question. What if you provide services in the homes of individuals that might have vulnerabilities? And I assume the question is, are we allowed to use sex offender registry information? Now, that is something that would need to be researched. I can't say I have personally encountered that situation. It strikes me on the face of it that there would certainly be a much better argument there that sort of information can be considered when the individual is going to be servicing individuals at risk, even if not working with them. But that's the type of thing that we'd want to research before an employer definitively made that determination.
Okay, next question. It says job related. Are we considering, quote, the essential functions of the job?
Yeah, so when you're evaluating criminal history information and you're trying to decide whether a conviction is or is not job related, are you evaluating the essential functions of the job? Yeah, I think the best practice would be to focus on the key aspects of the job and not to overemphasize very modest aspects of the job. But I can tell you that situations arise in which an individual may not be doing something a lot, but it's still important. So let's say, for example, that you have a sales employee that primarily works out of the office, but would sometimes make stops at individuals' homes, right? Maybe they do that only once every few weeks. In that situation, that's not perhaps quite as large a part of their job, but it is still a material part of their job. And you may have a situation in which the criminal conviction history is related even to that less time-consuming aspect of their job. It's the type of thing that we balance as we're evaluating whether a criminal conviction is or is not job-related, but that's a wonderful question.
Okay, this next one, Scott, you may want me to answer, but the question from Joe is, I'm an Orange Tree client. Are their forms, disclosures, communications compliant with California law? I can take this one. The answer is yes. We provide compliant, really 50-state compliant verbiage for authorization and disclosure language. A specific consideration for California is the ability to indicate if you are doing adverse actions, so the ability to indicate the offense that allowed you to not be able to consider them for employment. So we provide a fully compliant process specifically in California throughout the entire background screening process, but certainly on those bookends of the authorization and disclosure and the adverse action notification. Okay, a couple more questions here. What is the #1 mistake that gets employers sued in California?
Yeah, there's a lot of things that get employers sued in California, but I do think that background screening consent materials remain the #1 risk item. And the biggest reason I say that is just because the types of lawsuits that we see in that area are almost universally class actions. And so it's one thing to be dealing with a case that says, oh, you shouldn't have used that criminal conviction against that particular applicant, and it's a single plaintiff case. It's another thing to be dealing with a class action involving 1,000 or 5,000 or 10,000 applicants. And so we think the written consent process in particular is probably the #1 risk item under California law.
Okay, perfect. This is a question around the Ninth Circuit interpretation. Should we adjust our paperwork even if we do not have much of a presence in California?
Yeah, that's a good question too. I would say certainly what we're telling employers is background screening consent stuff is so often under attack now that the best practice is to comply with the most rigid interpretations, the most narrow interpretations, and to try to satisfy those interpretations. Because if we can satisfy the most narrow interpretations, we're probably best positioned to avoid problematic Ninth Circuit decisions. But also, we're more in position to avoid decisions from other circuits that might join the Ninth Circuit. At some point, we do think we're going to see kind of a grab bag of decisions. More liberal-leaning jurisdictions like the First Circuit and the Second Circuit, that's like Boston and New York, are likely to line up with the Ninth Circuit. And then we can imagine other circuits like the Fifth Circuit down by Texas that are going to be more forgiving, more open-minded as to the way employers construct forms. But to us, the best practice at this point is to try to comply with the most narrow, the most rigid interpretations. And yes, that means complying with the Ninth Circuit interpretation, even for those employers that don't really have a meaty presence in California.
Okay, thank you. I'm seeing one more question here. Do you expect more cities in California to enact the types of Fair Chance Act laws that we are seeing in San Francisco and Los Angeles?
Yeah, probably. It's kind of a bandwagon movement across the country right now. So not only are we seeing Fair Chance Act and ban the box laws popping up in California, but we're seeing them pop up all over the place. I think at this point there are something like 150 to 200 jurisdictions that have created Fair Chance Act and ban the box laws. Fair Chance Act are laws that essentially limit the ability of employers to consider criminal history information. Ban the box laws are laws that say an employer essentially has to wait longer into the process before asking a criminal history question or conducting a criminal background check. So yes, that movement is spreading, and we certainly expect it to continue spreading in California as well.
Okay, I'm seeing one more question in the chat. How does this all interact with negligent hiring laws?
Yeah, it's a wonderful question, right? Which is, okay, we see all these state and municipal laws that are making it harder for us, the employer, to use criminal history information. But at the same time, we face a negligent hiring risk on the other end, that if we do hire that person, then what if someone says that an individual was injured because we hired the wrong person and should have taken into account their criminal history background? It is a rock and the hard place type situation. There's no getting around it at this point. Some states are passing laws that essentially say if the employer properly complies with a Fair Chance Act law, then they are insulated from that sort of negligent hiring case. But I am not aware of California doing a solid for employers in that way. To my mind, California remains a risk on the negligent hiring front. And so where I come down at the end is it's sort of a balancing. It's sort of a balancing test. On the one hand, we want to account for these laws that are increasingly out there that limit our ability to use criminal, but at the same time, we do want to screen out the right people. And so the question is to try to be thoughtful about it so that we're screening out the right people and keeping out the wrong people. But I say that in quotes, and I acknowledge that it's tough to achieve perfection and that there is risk on both sides, as the question suggests.
Okay, perfect. Well, I think that wraps up with all of the questions, Scott. Thank you so much for a very interesting, very informative presentation. Just a reminder to everyone, the recording of the webinar and the slide deck will be available afterwards. We'll make sure to send that out to everyone. Let us know if you have any questions, but we appreciate your time today. Scott, thank you again, and thank you everyone for attending the webinar.
Thank you, everyone.